Hi everybody, we are on week 4. We're over the hump. We're into the final stretch of this class, and I'm hoping you're all looking forward to having a week off after this. I've hoped you've enjoyed this class as well. The courts I find very interesting. I always found them very interesting. On my off times when I had nothing really to do, I would go sit in a courtroom and I would listen to cases and see what kind of cases are heard, where they're heard, what exactly does it mean, because it's an entirely different language when you're in the courtroom. The courtroom has its own language, and quite frankly, sometimes it's pretty daunting to understand what they're talking about. So I wanted to go a little bit over about some of the fun things in the court, but some of the things that aren't so fun. The first thing I want to do is the courtroom layout. The courtroom layout is actually kind of fun to look at. You always have the judge's bench. Now, if you look at most courtrooms, you will see that the judge's bench sits higher. This goes back to Old English law. And the judge will usually wear a black robe. But there is no law that says a judge has to wear a black robe. In fact, we had a judge that was from the Great Barrington area that would wear a robe that matched the season. If it was Valentine's Day, he would wear a red one. If it was Christmas, a red one. If it was St. Patrick's, it would be a green one. He was always changing the color of his robes. He's no longer there, but he was a colorful character, truly. So that judge always sits taller, and usually you'll see that judge will come in it'll come from the side, and there'll be an announcement in the court that the judge is coming in, and everybody must rise. Everybody must rise for the judge, and when the judge leaves, the court officer will yell out that everybody must stand. In that, when you're looking down, in front of the judge will be the clerk of court and the court reporter. Court reporting is done many different ways, but for the most part now, they're all recorded. They're all recorded, and some of them have stenographers. Depending on the severity of the court, you'll see stenographers and both. You'll see both. So the clerk, think of the clerk as the manager of the court. The clerk is the one that puts the order of what's going to be heard, is directly there to aid the judge, and calls the cases forward. The clerk of court and the court reporter are directly in front of them, and then you'll have the witness stand to the side. Now, I bring this up because if you notice, the witness stand is here. Now, the witness stand can be attached, or it can be its own little set area. Here you have the defendant's table. The defendant, by law, always has to have a view of the witness. Which brings me to what happened during COVID. We had times where judges would have bail hearings and other hearings via camera, but you cannot have cross on a camera. So you can't have, if you have a kid witness, a young child as a witness, they can't be doing it by video. It has to be where the defendant must always have a view. So that means your defense attorney who's sitting here with the defendant and your prosecutor who is sitting here with maybe a second in charge can't stand in front to block it. There always must be a view. I know that painfully because I had a case where a young kid had to face his father, and our prosecutor walked in front of the defendant for a very short period of time, but he said he lost view during that time, and the case was thrown back to be retried. We then have the jury box. In the jury box, you'll count them 1, 2, 3, 4, 5, 6. Jury of 12, unless you're a juvenile. A juvenile has a jury of 6. So usually pick a couple alternates just in case something happens. This is the rail. Every court has this. I'm sure many of you have heard of attorneys who pass the bar. Well, this is the bar. This is the bar. There's a swinging door. If you are an attorney who has passed the bar exam, you get to sit on this side. There's chairs that are usually right here. That's who gets to sit on the other side of the bar. Passing the bar means you get to sit over here. I learned kind of the hard way on that, but I had a judge who really liked me who called me sidebar and said, you're sitting on the wrong side of the bar. I said, excuse me. He goes, you're sitting on the wrong side of the bar. You have to be an attorney to sit on that side. You need to sit on the benches for the public. So that's where I went. I went out this door and here. He didn't embarrass me in front of the court. I didn't know that, but I knew it for the rest of my career that I would never sit past the bar, past the swinging door. And every court has that. So you have the jury. You have usually seats right here on the other side of the rail. You have the swinging door, which is the bar, passing the bar, and benches for the public. Now, if you are there for the defense, you typically will sit in this side. If you're there for the prosecution, you'll sit on this side. On this end, most courts will have rooms, private rooms, where the defense can go talk to witnesses. So, and that is where you can't hear into them and where they can have privacy. So usually they'll have a court area that's out here that's blocked that nobody can see, that's to meet with witnesses. On week 4, we are going to be discussing, as I said, the adversarial, and now that we're off of what the courtroom looks like, and almost all your courtrooms look like that, okay? We have different courts, and they're pretty much structured the same way, the state courts and the federal courts. Some federal courts can hear cases that are heard in the state, but the vast majority of them, there's a jurisdiction issue. And I hope that you read this and you see the jurisdiction is one of the biggest issues we have to deal with in the courts. Who has jurisdiction to hear a case? Can if it crosses state lines and it involves things that have to do with the federal government, can they be heard in the federal court, or can they be heard in the state court? I'll give you an example. One of those would be The Perfect Poison. That's a book that was written on the Leeds murder case. Leeds is a house for veterans, and it's a federal hospital, or a federal, area. Leeds Hospital is federal. So a person there, a nurse there, was killing off patients. The book is called The Perfect Poison. And what happened was the federal government decided to take jurisdiction over the case. And there was a couple reasons the federal court decided to take jurisdiction. One is they can afford it more. That would have depleted the budget of the Northampton City prosecution, because that would have been a state court, but it would have been in the state court would have had to pay more money than it would have hurt them dramatically. There's other reasons too. Sometimes it's heard in federal court because the federal court has the death penalty, whereas the state court in Massachusetts does not. So there's different reasons that they can be heard in different areas. So, getting back to the adversarial system of the justice, it establishes that each side in a court proceeding should endeavor to win the proceedings with the limits of the law and the rules of the court. Think of the judge as he's the person that oversees the match, like a boxing match. He's the one that oversees to make sure everybody goes by the rules. He makes sure that the rules and that the jury are all there, and that there's no that everything is represented correctly. So it's called the adversarial system, or the adversary system is a legal system used in common law countries, which is ours, where two advocates represent their party's case or position before an impartial person or group of people. So a jury of your peers. It's hard to have a jury of your peers when you have a juvenile court case, because you're not going to be bringing in all the high school kids. A judge can hear a case, or a jury can hear it. If it's a judge that hears it, it's called a bench trial. If a jury hears it, it's a jury trial. They try at that point, it is an attempt to determine the truth and pass judgment accordingly. So we look at evidence. The prosecution has a legal obligation under criminal law to disclose exculpatory. That was one of those words I'd never understood until I sat in a courtroom and paid particular attention to what exculpatory meant. It means you can't hide anything as a prosecution. If you hide something, you legally will be held responsible for that. The prosecutor is legally bound to give over all the evidence that they have. They cannot hide it. So that's everywhere. Every court has what they call the Brady Rule, after the Supreme Court case had found that, was that every single bit of evidence must be turned over. Now, my question to you on that would mean, do we have to allow the courts, do we have to have the prosecution, not the prosecution, but the defense, do they have to give us all their evidence? Well, they certainly do if they plan on using it. They have to give us who all the witnesses are. And there's, you can find that as anywhere. Procedure for discovery. I'm going to send this on this, and this has to do with the discovery. Discovery means every bit of evidence has to be turned over, written, or it doesn't matter. It's written, recorded statements must be turned over. If it goes before a grand jury because it's a case that can't be heard in the district court level, there's many, many cases that cannot be heard in the district court level. Rape can't be heard in the district court level. Another case that can't be heard is murder. Those can't be heard in the district court level, and we're going to talk a little bit about that in a minute. But I'm going to send this to you because it will tell you all the ways that evidence gets in, and it's a pretty interesting thing. So that's in Massachusetts. I know you have your own states. Getting back, so you have to look at this now. Why is it so important? Well, these cases, I highlighted these cases because to this day, Matt v. Ohio, Miranda v. Arizona, and Terry v. Ohio are all still in play. Terry versus Ohio is the stop and frisk. Miranda, we all know Miranda, and if you look up Miranda, you're going to say to yourself, oh, that was not really a nice guy. But the reality of it is the law was broken, or the law had to be amended because everybody has the right to remain silent. All right. Matt v. Ohio. So when you say to yourself, do they have the right to, do I have to give Miranda if I'm going to question somebody? If they are the focus and if they are in custody. In custody really is defined by the court, whether they're in custody or not. Like the court is defined, if I pull somebody over in a cruiser, that's custody. But if I see somebody walking down the street and say, hey, how you doing? And he says, hey, I just murdered my mother. That's not custody. That's just casual conversation that turned into something, it turned into a crime. The Matt v. Ohio is a landmark one, which is the exclusionary rule. That is the fruits of the forbidden fruit. You can't admit it, so it's a legal search. I have to tell you that there was times cases were found. As a police officer, you will always have cases that will go for you and against you. And sometimes you're like, oh, how did that happen? Because I followed what I thought was the letter of the law. But I did have a kid who had his case where they took away. They said that we wouldn't be allowed to add some drugs. And he showed up at the police station the next day and he says, hey, I'd like those back. I'm like, well, just because the court says we can't use them against you, we still can't give them to you. I actually gave him like an A for effort. So then that assignment there, when we look at this at the end, you are going to be looking at, based upon what you've learned of our courses resource, you'll look at the adversarial nature of criminal courts. All right, and I want you to see, and you can look at the pros and cons of it. I can tell you pros and cons of it that you probably haven't thought of. And one of them is, because of this, everybody has a right to a good trial. When we look at the O.J. Simpson trial cost the taxpayers of Los Angeles over $9 million. Over $9 million. And when we look at cases that cost a lot of money, we can look of that. Now, keep in mind, of the total of that, that $9 million, they also had to pay for, specialists. It was like an awful lot of money that came back at the taxpayers. When we look at other trials, the McMartin preschool molestation case was a case that really formed how I did my investigations, and it really needed to be. It changed the way child sexual assaults were investigated. In a nutshell, the McMartin case had one investigator interview all the kids and interviewed exactly the same way. You can't have that. If you have multiple victims, you need to have multiple investigators and multiple interviewers. That cost the taxpayers $13.2 million. $13.2 million. And when you look at the Night Stalker case, that was $1.8 million. And when you look at the Charles Manson case, that one there was not too bad. $768,838. That's what that cost. Think of the Bundy case. Think of, the cases out there that are the Casey Anthony case from Florida, the George Zimmerman, the Scott Peterson, the Timothy McVeigh. Those can be very cost prohibitive, but you're required by law to do that. So they do pay that, and it comes out of our taxpayers' dollars. Now let's say that somebody's given a court-appointed attorney, which, by the way, they are very good attorneys. I would have no qualms with any of the court-appointed attorneys that I dealt with hiring them. They were very, very good. They're required to, or you can sue them. So if you have a court-appointed attorney and they need a specialist, they can petition the court to pay for that. And I had that happen in one of my cases where it was over $400,000 for specialists that the state, or actually the city, the Hamden County had to pay for. So keep in mind that there's